Hello everyone, welcome back to our daily issue analysis DIA. And today we have taken another topic from the current affairs and we will analyze it from all the dimensions in a holistic manner which will help you in developing a good understanding. So let's start for the day. So the topic which we have chosen for the day is marital rape. Yes, so this is very much in news and for different purposes we will discuss in detail why it in news and other dimensions related to it. So first we'll start and see the definition. The important components of the definitions are forcing, spouse, sexual intercourse, no consent. So the idea is that even if you don't remember the whole definition, you can create your own definition. Just these keywords should be there in your definition. So it says that marital rape is the act of forcing whom your spouse into what into sexual intercourse, having sexual intercourse without proper consent or no consent. So this is the simple definition of marital rape. Now, this is in news rather, is because of section 375 of IPC. Actually, this 375 section of IPC defines rape, and this is in news because it holistically defines rape, but there is an exemption. It contains an exemption, and the exemption is sexual intercourse by man with his own wife will be not considered rape even without if it is happening even without consent. So the whole issue is if it should be there in IPC or there should some reform should be there. So this is the contention. This is the issue that we have to remove this exemption, other because of which many women are not getting justice in the case of marital rape because there is no recognition at all. Okay. Now we'll see the origin of law and other related issues. Now let's understand the origin of this law. So this law, like any other law, has a colonial legacy. And in those times when this law was introduced, that is around this IPC was drafted in 1860s. At that time, they followed doctrine of coverture. So what is this doctrine of coverture? Basically, this doctrine says that talks about the merging of women's identity with that of her husband after the marriage. So after marriage, the women will have will not have any identity of their own, and they will be not considered as any independent legal entity. So a married woman was not considered as an independent legal entity. So doctrine of coverture is based around this, and this Victorian norm was based on the pillars of patriarchy that they did not recognize men and women as equal. So post marriage, after marriage, they were not considered as equal. As we know that the identities were merged. Okay, so this is all about doctrine of coverture. And not only that, because of this, they did not allow married women to have their own property. So this was revolving around patriarchy. And it was that time when 1860s, it was that time when IPC was drafted. And since then, this law, these sections are there and it is still there in India and we are following it. So we are talking about reforming or bringing change in these sections. Now we will discuss the arguments that why people are opposing any law or any action on recognition of marital rape. So people consider that it will destabilize the institution of marriage. So marriage as an institution is considered as sacred, and it is said that whatever is happening within the four walls, if it is going to the legal corridors, if it is people are talking about it, society is talking about it, then it destabilizes the institution of marriage. And it is also said that the sanctity of the institution is lost because it is considered as sacred, so it will be compromised, it will be destabilized. So this is one argument that why recognition should not be given. Argument opposing marital rape. Second, it is said that there are certain duties and obligations when people enter into this institution of marriage, and marriage was accompanied by obligations that a partner had to do, be it taking care of the progeny or bearing a child, And not only that, uh, even including conjugal expectation, financial obligations has to be shared. So even conjugal expectation is considered as one of the duties and obligations. So as a part of that, if certain expectations are there and if it is not being fulfilled, and even some intercourse is happening without consent, then it should not be considered as a rape. Rather, it is one of the duties and obligations. Okay, so this is second argument opposing the marital rape. Third, often people who oppose marital rape, they also argue that already we have a legal framework in place, that is section 3 of Protection of Women from Domestic Violence Act 2005 is there. And under this act, the section 3 is talking about that if what all comes under domestic violence. So the definition of domestic violence is very broad here, which includes physical, mental, emotional, verbal, and even sexual abuse. So if any woman is being exploited or being abused sexually also, that can be considered, or women can go and seek help under this Protection of Women from Domestic Violence Act 2005 under section 3. So it is said that when we have already a legal framework in place, then why do we need to define marital rape separately or seek any uh, uh, help and separately? So this is the third argument. Now we will see the other arguments opposing marital rape. The fourth one is scope for misuse will be there. So people say that in how if we are coming up with a issue related to marital rape, we are coming with a section related to marital rape, then there will be scope of misuse, because the signs of injury on partner's body need not necessarily mean there had been non-consensual sex, because we are living in this age of sexual liberation. We are living in this age where passionately people are involved in this sexual intercourse. So these injuries could be sign of passion. So there could be scope of misuse as well. Just by observing the signs of injury on the partner's body, we cannot accept it whether it is part of marital rape or not. Next, it is also being discussed that even if we come up with a law, then the implementation will be biggest issue, because how to create this or how to develop this understanding that whatever is happening between two partners within four walls is a marital rape or not. Now what the partner should do, shall they sign a accord, shall they sign some agreement that okay, what will include of marital rape and what will not include? Shall they always maintain a record of all the intimacies which is happening between them? No, that is also not possible. Then shall they invite any third party to act as a witness? That is also not possible, that is also not healthy. So this a whole institution, marriage as an institution, is sacred, and thus any involvement or any record maintenance and nothing is possible. Practically, that is not possible. Then how it will be implemented? The implementation, creating a detailed evidence or maintaining a record of the intimacies, that is not possible. So implementation is being questioned. Next, it is also said that in a marriage, when two partners are coming together, then there will be differences. Resolving these differences, in fact, helps in strengthening the marital bond. And you know why we are discussing this issue all together today? Because this has been said by Delhi High Court itself. One judge in the Delhi High Court, the Delhi High Court judge, they have come up with a split verdict on marital rape. Split verdict means that one judge has favored it, one judge has opposed it. So Delhi High Court judge in the split verdict, who is opposing marital rape, has said that even the disagreements in marriage, including the this non-consensual act also, is part of marriage. It is natural and may even lend strengthen the marital bond. So that what he is saying, judge is saying that it is part of agreement and disagreement, they are part of the marriage. So categorically we cannot say that this is marital rape. Rather, the differences are part and parcel of the marriage. So we should not think like that. Now we will discuss about the argument supporting marital rape. Why there should be a law or there should be recognition of marital rape. So the first argument is the widespread presence of marital rape. So there was a survey, NFHS 5. This data was collected in the period of 2019 and 2021. The data highlights that over 93% of women in India endures sexual violence at the hands of their husband. So they are facing it. And not only that, out of that, 90% of them are not seeking help. They are not taking legal recourse. They are not seeking any help for that matter. So the argument is that already this issue of marital rape is widespread, and the surveys, the data are also showing that, but there is no uh, uh, solution. Next argument is vulnerability. So there was a survey done by NFHS only, and it was observed that 27% of married women are only employed compared to 92% of married men. So in a if we analyze, so 92% of men are working, and only 27% of women are working. So now in that case, what is the vulnerability? So in a survey, it was also found when it was asked whether from men, it was asked that what if your wife is not agreeing for a conjugal expectation? So what will you do? So 20% of men told that they will reprimand wives for saying no to conjugal expectation. 13% told that they will withdraw the financial support. So now in this case, if women, they have lot of they become vulnerable. So when only 27% of married women are working or employed, then it is a threat for them. Sometimes even they are undergoing this marital rape issue, they don't come out and talk about it because they have this fear, what if the husband will withdraw the financial support, where they will go after marriage? So because of this, they are being exploited. So this is another argument. Next argument is with respect to the sexual agency. So it is said that it doesn't mean that if a woman has entered into matrimony, means if they have got married, so it doesn't mean that their sexual agency or the sexual autonomy would be taken. Marriage is a relationship of equals, and even women have equal rights. So it doesn't mean that they have to agree to whatever their husbands are saying. They also have their right to bodily integrity, and thus it should be respected. So these are the three arguments related to supporting law on marital rape. We'll see few of the other arguments. Another set of arguments are starting with the fourth one about constitutional right. It is said that under Article 21, even women have right to life and liberty, which gets compromised if the issue of marital rape is happening, because even Constitution is conferring or guaranteeing basic dignity to every individual, and the right to bodily autonomy is part of Article 21. It is a part of right to life and liberty, so it gets compromised if this issue of marital rape is happening. So for that, they are supporting it. Next argument is with respect to demarcating spheres. So this argument says that we cannot artificially demarcate public and private sphere. So whatever is happening publicly, we consider it as a crime, we consider it as rape. Whatever is happening within the four walls, we consider it as a private matter. It should not happen. Crime is crime, whether it is done when unmarried or done when we are getting married. So it is a crime, it should be recognized. So this is another argument. Other argument is related to issue of proof. So we have discussed arguments opposing marital rape, recognition of marital rape, that there is an issue of proving the element of how to prove that whatever has happened within the four walls, how to prove that. So this argument is saying it is just that because we cannot prove it, we cannot close our eye to rape merely because it is difficult to prove. It is difficult to implement. So we have to find a solution. We cannot discard it. We cannot say that no, it is not there. So we have to find a solution, definitely. But just on the context or premise of that issue of proof how to implement it, we cannot discard it. So we have to find a solution. So this is another set of argument. Now we'll see few more arguments. Other set of arguments which support marital rape should be recognized includes is around weakening of marriage. So earlier we have seen the argument that why it should not be given recognition. We discussed that it says that it leads to weakening of the marriage as an institution. The sanctity or the sacredness gets compromised. So the argument is that more than 100 countries have already considered marital rape as an offense. They have recognized it, but nowhere we have got any evidence of weakening or destruction of marriage and institution. So in those countries where it has been recognized, even there it has not affected marriage and as an institution. So how we can say that it will weaken the institution of marriage in India? So this is one argument. Next is with respect to violation of Article 14. So the Article 14 gives right to equality to both men and women, and it is the it is mentioned in our constitution. So marital rape violates the this right to equality enshrined in Article 14. How that? Because we are considering men and women as equal. So whatever is happening, if women are facing some problem, so it is disturbing, it is creating problem for them. So it is no way that we are ensuring this equal right to equality under Article 14. And not only that, under Article 14 also we have given certain exemption to socioeconomic caste. Even women have been given certain exemption, and even under that also, if further if we give one more category like married women and unmarried women, then it will be unconstitutional. So any form of differential treatment of married and unmarried women, like okay, Article 14 is good for unmarried women, and married women, even if they are facing problem, they are not equal to men, so that will become unconstitutional. So it is violation of Article 14 as well. Next, that the judge which we were talking about, Delhi High Court judge who has supported the marital rape, this Delhi High Court judge Rajiv Shikdar is saying, has mentioned that right to withdraw consent forms very core component of women's right to life and liberty. So it should be recognized. So he's supporting marital rape, and it is the women's right to withdraw the consent. So if no means no, if they don't want, then it should not be forced upon. So these were the arguments, 9 arguments revolving around that why marital rape should be recognized and there should be a law to support that and for the resolution. Now we'll see certain international situations. Now we'll see certain international scenario that what is the situation in other countries. So we have already discussed that more than 100 countries have already enacted laws criminalizing marital rape. So Australia is one of them, Canada, South Africa, and United Kingdom. So irony is that United Kingdom introduced this section under IPC, the exception under the, IPC, and today they have only enacted a law criminalizing marital rape, and we are following that law itself, but still we have not repealed that. Not only that, in 2013, UN Committee on Elimination of Discrimination Against Women, that is CEDAW, they recommended that Indian government should criminalize marital rape. So these are the two uh, points which you can take help in order to substantiate your answer. We'll see certain judgments related to the same. Now we'll see important judgments related to marital rape. The first one being the state of Karnataka versus Krishnappa. In this, non-consensual sex was recognized as a part of sexual violence. Means non-consensual sex is equal to sexual violence, and sexual violence is equal to unlawful intrusion into privacy. So this was recognized. Also, we have another judgment, Suchita Srivastava versus Chandigarh administration. In this, right to make choices about sexual activity was considered as the part of Article 21, that is right to life and liberty. So this is also a judgment which is supporting. Next, Justice K.S. Puttaswamy versus Union of India, we know that it recognized right to privacy as the part of fundamental right, Article 21. And right to privacy has different dimensions, under which decisional privacy, especially related to decisions in inmate relations, when they were analyzing section 377, this decision in inmate relation is very much part of the right to privacy. So in that they are supporting that the women also have their right to privacy with respect to such decisions if they are saying no to such things. Okay, so these were the important judgments. We will see the way forward, what stand we should take in conclusion. Now, when you are talking about way forward in the answer, in the conclusion, what you should write, so conclude on these lines that the socio-cultural situation or the conditions have changed. It was introduced in 1860s, and at that time patriarchy was at the core and women were not considered equal. Now we are considering women as equal. Post independence, we have our constitution which gives recognition to women, and they are considered at par with men. So the socio-cultural scenario has changed. Now we are talking about our rights. We are vocal about rights. So the conditions have changed. No more the colonial hangover should be there. Next, not only that, even Justice J.S. Verma, after Nirbhaya case, they also supported that yes, marital rape should be recognized and it is a matter of grave concern. It should be recognized. Also, we should not only talk about the legal recourse or legal mandate that yes, legal recognition should be given, but also we should talk about change in attitude. Always in your answers, give this dimension of change in attitude and behavior, because let's say even if we come up with a law, but how many of women will go and claim, or how many of women will come and will talk about it openly? So we should focus on change in attitude of the individual, male, family, the attitude of the society, attitude of the criminal justice system, the police, the prosecutors, and not only that, even women, they should be also vocal about their rights. They should also think from their perspective. So change in attitude is very important, even if we come up with a legal mandate. Okay, so think about all these things and then suggest a way forward. And with this, we end up our discussion of marital rape. Hope it added value to your preparation. Thank you so much. Let us know your feedback. Let us know if anything you want to add in the comment section. And we'll meet in the next video. Take care. Bye bye. See you all.